that given that in the 19th century, international law had made no such provision for the preservation of international peace, this was an extremely ambitious step forward. Approximately a decade later, an unprecedented wholesale ban on war through international law was introduced. In 1928, the General Treaty for the Renunciation of War, also known as the Kellogg-Briand Pact, bound 63 states to give up warfare entirely and to seek a peaceful resolution of all disputes arising between them. 1928, the first real attempt to completely ban warfare. We're talking nearly 100 years ago now. The first two articles of the Briand-Kellogg Pact provided that the high contracting parties, that is the states, solemnly declare in the names of their respective peoples that they condemn recourse to war for the solution of international controversies and renounce it as an instrument of national policy in their relations with one another, and that they agree that the settlement or solution of all disputes or conflicts of whatever nature or of whatever origin they may be, which arise between the states, shall never be sought except by pacific means. Now, the first of these two articles has a declaratory character, confirming that the states' renunciation of war entails basically that they can no longer have this as an instrument of national policy. The second article prescribes that the settlement or solution of all disputes or conflicts shall never be sought except by pacific means. This is a legally binding provision, although it does importantly lack a mechanism for its enforcement. So although states say we are legally bound by this, there's nothing in the Briand-Kellogg Pact saying what happens if states don't actually abide by these rules. And this is one of the big problems of international law, honestly, as a mechanism for the preservation of international peace, that the consequences of breaking international rules are often not as severe as the consequences of breaking rules in domestic law. However, on the basis of these provisions of the Briand-Kellogg Pact and indeed the Covenant of the League of Nations, the forcible acquisition of territory by conquest became both illegitimate and illegal, and indeed it was foreseen that individual criminal liability might even attach to those who pursued it. The Briand-Kellogg Pact was invoked several times before 1939. However, unfortunately, neither it nor the League of Nations Covenant were able to prevent the outbreak of the Second World War. One unforeseen outcome of the Briand-Kellogg Pact was that it effectively erased one of the clearest legal distinctions between war and peace, because previously states had always declared war, and now states wanted to states that might have wanted to engage in forcible measures against their neighbors engaged in wars without actually declaring them. In fact, the practice of declaring war, while it would occasionally still occur, shifted from something states had seen as a legal necessity to begin a conflict before the 1920s to something thereafter seen as optional, typically deployed for political purposes. The Briand-Kellogg Pact was concluded outside the League of Nations, and while it remains in effect, the usage of the word war, rather than the wider and the more modern concept of force, means that its relevance for contemporary politics and contemporary international law is somewhat limited. Nonetheless, the importance of the changes brought about during the period between the First and Second World Wars should not be understated. In criminalizing war, the Briand-Kellogg Pact played a role in the development of a new norm of behavior in international relations. one based on norms that continue to play a role in our current international order, which is founded on the United Nations Charter. This document, concluded after the end of the Second World War, provides some guidance for the creation and interpretation of international law of war and peace. So the single most important international treaty prohibiting the use of force nowadays is the Charter of the United Nations, which is the foundational treaty establishing the United Nations organization. The United Nations Charter creates an international mechanism which requires states both to impose limits on their own right to resort to force and to depend on a collective response for protection. The mechanism aims to centralize the use of force under the control of the United Nations Security Council. In contrast to the ambiguous language employed both in the Brion-Kellogg Pact and the Covenant of the League of Nations, the United Nations Charter seeks to identify a single agent, namely the United Nations Security Council, as having the power to interpret the implications of conflicts and crises, and to determine for international society as a whole whether a breach of the peace has occurred. Subject to Article 4 of the Charter, the primary responsibility for maintaining international peace and security lies with the Security Council. This is very significant because obviously we said at the beginning of this lecture that effectively states in international law are both the rule makers and the rule takers, but they are importantly also norm interpreters. So while there are some international courts, generally speaking, it falls to states to determine the legal limits of particular legal norms and to determine their meaning. And in this context, it's quite significant that the United Nations Charter in 1945 effectively conferred upon the United Nations Security Council, rather than each state individually, just the members of the United Nations Security Council, the power to determine when there has been a breach to international peace and security. So effectively, states are not supposed to decide upon this fact themselves. Rather, the authoritative norm interpreter here is the United Nations Security Council, and it should take a position on whether there has been a breach of international peace and security. As we shall see, however, there are some faults with this model. Article 2 of the United Nations Charter sets conditions on the use of force in international relations. The Charter also contains Chapter 7, Articles 39 to 51, which stipulate courses of conduct in the face of a variety of threats to international peace and security. According to Article 39 of the Charter, the Security Council alone determines any threat to the peace, breach of the peace, or act of aggression, and decides which measures shall be taken to respond to this threat or breach of the peace in accordance with Articles 41 and 42 of the Charter. Article 41 of the Charter empowers the Security Council to decide on measures not involving the use of armed force, such as complete or partial interruption of economic relations, or of rail, sea, air, postal, telegraphic, radio, and other means of communication, or the severance of diplomatic relations. Nowadays, we would probably call these measures sanctions. In the 1990s and the 2000s, the Security Council made use of these powers in a variety of creative ways, including through the establishment of international criminal tribunals for the former Yugoslavia and for Rwanda to provide redress and accountability for the atrocities that had occurred in these states, and through a variety of responses to international terrorism, including ordering freezing of assets and bank accounts of persons identified as having been implicated in the funding of terrorism. Generally, there is believed to be no restrictions upon how the Council may make use of its powers under Article 41, subject to compliance with peremptory norms of international law and other provisions of the United Nations Charter. And the Council's creativity in such circumstances is to be commended, as it removes the necessity to use armed force, which is also an option open to the Council on the basis of Article 42. Article 42 authorizes the Security Council to use force in circumstances where force would normally be illegal. This is, again, an unfettered power, subject to compliance with peremptory norms of international law. As such, the Security Council is not obliged to first impose economic sanctions or other lesser measures before using force, or to wait to see if such lesser measures have been ineffective before it authorizes the use of force, although in practice it has more or less always done so, reflecting perhaps a healthy aversion towards employing its most devastating powers and reflecting the general commitment of the United Nations towards the preservation of international peace. It follows from Article 42 that states may also be authorized, although not required, by the Security Council to use force. The fact that states cannot be compelled by the Security Council to use force is, however, something of a problem with regard to making the powers in Article 42 effective. Because although the UN Security Council may authorize force by states, it can't compel them to send their armies to deal with a situation where there is a breach to international peace and security. If force is required to put an end to a conflict, and if the Security Council is ready to authorize such force, then a state or a group of states must stand ready or must provide resources to make this force effective in practice. However, the following articles, Articles 43 to 47, concerning the availability of forces to put at the disposal of the United Nations, have never been triggered. In fact, they have, from the beginning of the United Nations organization, been seen as something of a dead letter. This entails that the United Nations does not have a standing army or even a limited rapid reaction force, and that in reality, even when the United Nations authorizes force, forces must be committed by individual states to individual missions on an individual basis. As such, the authorization of the UN Security Council in some respects harks back to the days when the Pope or an emperor would determine whether a particular conflict was or was not just in the circumstances. The remit of the concept of just war stretches to considerations concerning how warfare should and can be conducted, as well as how states should behave themselves after the war has ended. From the present day perspective, the concept invites scholars and practitioners to revisit the questions of ethics of war and related cultural and religious approaches to thinking about war. Some of these old philosophical issues may raise contemporary issues, since the existing laws on the use of force are fashioned after traditional theories of just war. For example, whether only defensive war is legitimate, because the United Nations Charter provides for, as we shall see, a self-defense exception to the prohibition on the use of force. What circumstances justify waging a defensive war, or how to fulfill the requirements of necessity and proportionality. The focal point of the Charter regime regulating the use of force is situated in Article 2 of the Charter. Crucial for our understanding of this regime are paragraphs 3 and 4 of Article 2. So Article 2.3 and Article 2.4. Article 2.3 prescribes that all members of the United Nations should settle their international disputes by peaceful means in such a manner that international peace and security and justice are not endangered. So basically, they say the first port of call when you have a problem should be to settle it by peaceful means. Article 2.4 says that all members of the United Nations shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of the United Nations. Now, this provision set out in Article 2.4 of the United Nations Charter is characterized as both peremptory and customary in nature. In contrast to the interwar period, the provision does not distinguish between war and the use of force that may fall short of war, for example, reprisals or maritime blockades. As such, it embraces and prohibits all threats of and acts of violence without distinction. Functionally, paragraph 4 is preventive. It discourages governments from disturbing the peace by using force against other states or by threatening to use force. Despite a certain overlap with the rule of non-intervention in Article 2, paragraph 7, the words "in their international relations," as well as the normative predecessors of Article 2, paragraph 4, which we talked about in the Brion-Kellogg Pact, reveal that the provision is meant to cover the relations of one sovereign state towards another, rather than one sovereign state intervening within the internal affairs of another. The core objective of the provision is to abolish wars as a means of forcing a state to act in a certain way and to submit to the will of the aggressor. In its resolutions, the United Nations Security Council only rarely refers to Article 2, paragraph 4 expressly. A breach of Article 2, paragraph 4 can be inferred, however, where the Security Council, for instance, condemns a particular use of force. However, as a political body, the Security Council generally prefers not to condemn, but rather to try to secure a settlement without assigning blame or legal responsibility under Article 2, paragraph 4. So it is more common for it to call in general terms for an end to the hostilities, the withdrawal of troops by both sides, and for the peaceful settlement of a dispute, or for the observance of ceasefires. Now, Article 2, paragraph 4 of the Charter has been supplemented by the non-binding yet influential 1970 General Assembly Declaration on Principles of International Law concerning friendly relations and cooperation among states in accordance with the Charter of the United Nations. It's usually called the Friendly Relations Declaration, and it was adopted by the UN General Assembly. Its drafting was sponsored by 64 states. The document confirms the agreement amongst the parties on the need for complete disarmament, on their respect for political independence and territorial integrity of states, and for human rights, including people's right to self-determination, and on other issues that we will talk about a little later. Yes, it's generally accepted that the 1970 Declaration is an authoritative interpretation of principles of international law as expressed in the United Nations Charter. In essence, the principles formulated in the 1970 Declaration are concerned with peace within states, with the relationship between states and peoples, with the principle of state sovereignty, with the settlement of disputes, with cooperation, and with other issues. As regards the prohibition of the use of force, the crucial prescription of the 1970 Declaration is that it regards any aggression of a state to another state as a breach of the principle of the prohibition of the signaled intention to use force, since any war of aggression constitutes a crime against peace. Moreover, in more modern terms, a war of aggression can derive into a crime of aggression, as stated in Article 8 bis of the Rome Statute of the International Criminal Court, which notes that such a crime means the planning, preparation, initiation, or execution by a person in a position effectively to exercise control over or to direct the political or military action of a state of an act of aggression which by its character, gravity, and scale constitutes a manifest violation of the Charter of the United Nations. The 1970 Declaration is further a confirmation of a customary rule of non-intervention in other states. This was confirmed by the International Court of Justice in its case concerning military and paramilitary activities in and against Nicaragua in 1986. This has further restricted legal recourse to the use of force by states. According to Article 2, Paragraph 4 of the United Nations Charter, members of the United Nations must refrain from the threat or the use of force. While the term use in the context of armed force is reasonably clear, the term threat remains uncertain. The reason is, of course, that some threats of force, explicit or implicit, remain an intrinsic part of everyday life on the international plane. There will always be disparities in power between states. And much like the fact that economically strong states do not need to threaten trade wars directly to secure trade deals on favorable terms with smaller states, militarily strong states do not necessarily need to explicitly flex their military muscles to secure certain concessions from their neighbors. However, this threat is far less present in modern international relations than was previously the case, indicating that the prohibition contained in Article 2, Paragraph 4 has a significant impact and is something with which states are happy to engage. It may be summarized that a threat of force consists in an express or implied promise by a government of a resort to force conditional on non-acceptance of certain demands of that government. The International Court of Justice's advisory opinion to the General Assembly on the legality of threat or use of nuclear weapons in 1996 provides examples of threats to secure territory from another state or causing it to follow or not to follow certain political or economic paths. While the mere possession of nuclear weapons did not in and of itself constitute a threat, the projected use of the weapons as a means of self-defense could be considered disproportionate and hence illegal as a threat to use force. We should also look at the word force itself. As we mentioned, force is a concept that is wider than that of war, which had been used in previous documents like the Covenant of the League of Nations and the Briand-Kellogg Pact. As such, force can be something less than war. It may involve isolated military attacks, for example. But just how much wider it is has been a point of great contention amongst legal scholars and indeed amongst states themselves. It was suggested that the historical purpose of the provision was to outlaw armed force and so-called gunboat diplomacy in relations between states. While developed nations advocated the more conservative understanding as force meaning armed force, developing nations used the wording of both the preamble of the United Nations Charter and Article 51, which operate with the term armed attack, to argue for a wider meaning, one encompassing economic force and other means of non-military coercion, as well as military force. Some argue that the evidence from the preparatory works that led to the adoption of the United Nations Charter lends support to extensive interpretation, given that this phrasing was introduced to provide guarantees to small states and was not intended to have a restrictive effect. Furthermore, the 1970 Friendly Relations Declaration referred to the duty of states to refrain from military, political, economic, or other forms of coercion aimed against the political independence or territorial integrity of any state. To some extent, developed nations did concede that economic and political pressure could constitute illegal intervention. This was set out by the 1970 Friendly Relations Declaration, which we just mentioned, which expresses a wide agreement on the existing obligations and which prohibits economic coercion. However, the notion remains undefined, and in its military activities in and against Nicaragua case in 1986, the International Court of Justice denied that American economic sanctions against Nicaragua constituted a breach of the customary law principle of non-intervention. As such, it would seem that economic sanctions are not entirely prohibited by international law and have been distinguished and separated by consistent and long-standing state practice from the notion of the use of force by states, which is prohibited by Article 2, Paragraph 4 of the United Nations Charter. Even today, we can see that this distinction is alive and well. And we can see this from, for example, the fact that many countries in the European Union are not slow to engage in economic sanctions against the Russian Federation on foot of their war in Ukraine. But given that the United Nations Security Council has not authorized the use of force against the Russian Federation, of course, it's very unlikely to do so, given that the Russian Federation has a permanent seat on the Security Council. The members of the European Union are very unlikely to engage in the use of force against the Russian Federation, believing it to be, well, number one, ill-advised because of the Russian Federation's possession of nuclear weapons, but number two, potentially not legal under international law, although it could be considered as collective self-defense if an alliance were forged between the countries of the European Union and Ukraine. But we shall discuss that a little bit later. Another example is the economic sanctions engaged in by the United States against Iran in recent years. Again, these sanctions are, well, they're being used for a number of reasons, but they're being used to constrain the Iranian government to act in a particular way. However, the United States does not see itself as breaching international law by using economic coercive measures, whereas even having one soldier set foot on Iranian soil, even though that individual soldier might do a lot less damage to Iran, the Iranian people, the Iranian economy, et cetera, than this package of economic sanctions. Having the soldier set foot on Iranian soil would be a clear breach of the prohibition in Article 2, Paragraph 4 of the United Nations Charter, whereas the economic sanctions are not seen to be a breach of the prohibition of the use of force. It should also be mentioned that Article 2, Paragraph 4 of the United Nations Charter talks about force against the territorial integrity or political independence of any state. Now, most international law scholars say that this phrase should be afforded a strict interpretation, and the second part of the phrase, territorial integrity and political independence of any state, should not be construed to refer to a particular threshold which must be reached by threats and uses of force in order to render them illegal. Rather, far from restricting the scope of the prohibition, these words were inserted as a guarantee for small states to reinforce the impermissible character of recourses to force against a state. This assertion is further evidenced by the rejection of a more supple interpretation of this phrase by the International Court of Justice in its Corfu Channel United Kingdom against Albania case in 1949. However, the United Nations Charter does not completely ban war, or indeed the use of force. Rather, it provides for a general prohibition with a couple of exceptions. As such, in order for the use of force by a state or states to be legitimate and in accordance with international law, it must fall within one of the accepted exceptions. These are self-defense, which is provided for by Article 51 of the Charter, and enforcement action mandated by the Security Council, which is provided for by Article 44 of the Charter. However, there has also been argued to be further exceptions. So some international legal scholars will argue for two further exceptions. Number one, the protection of a state's nationals who are living abroad. And number two, so-called humanitarian intervention. It has been argued by certain legal scholars that the maltreatment of foreign nationals threatens international peace and creates an international problem, thereby causing the situation to fall beyond the domestic jurisdiction of the state that is maltreating these individuals. One of the most well-known examples of the application of the doctrine of the protection of a state's nationals abroad is the intervention of the Israeli Defense Force in Entebbe Airport in Uganda in 1976. The Israeli ambassador to the United Nations, Chaim Herzog, argued in line with the opinion of a prominent international legal scholar, D.P. O'Connell, that Article 2, Paragraph 4 of the United Nations Charter is not violated if the state uses force in order to protect a state's own integrity and its nationals' vital interests when the machinery envisaged by the United Nations Charter is ineffective in the situation. Whereas the doctrine of the protection of a state's nationals abroad relates to a state's protection of its own citizens beyond its state borders, humanitarian intervention usually refers to the protection of the human rights of individuals in another state's territory. A prominent example of this, and one that we will probably discuss in more detail later on, is the air campaign undertaken by NATO in 1999 in Serbia to protect the Kosovar minority in that country. The acts prohibited under paragraph 2, under Article 2, paragraph 4 of the United Nations Charter may be valid, however, if they're undertaken in accordance with individual or collective self-defense. Accordingly, Article 51 of the United Nations Charter reserves the right of individual or collective self-defense for states if an armed attack has occurred against a member of the United Nations. So Article 51 provides, nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations until the Security Council has taken measures necessary to maintain international peace and security. Measures taken by members in the exercise of this right of self-defense shall be immediately reported to the Security Council and shall not in any way affect the authority and responsibility of the Security Council under the present charter to take at any time such action as it deems necessary in order to maintain or restore international peace and security. Now, it should be said that Article 51 was seen as a necessary inclusion in the Charter of the United Nations, because although it was already a very ambitious plan in 1945 to sort of make war generally illegal, the drafters of the charter had to be realistic about what they could achieve. And it was never going to be the case that states were going to sign up to an international system whereby if they were attacked, it was illegal for them to defend themselves. So there was always going to have to be an explicit exception to the general prohibition upon the use of force by states in favor of self-defense. So that was always going to have to be something that was included in any system, even if the main purpose of the system was to prohibit warfare. However, there are certain interesting features about this. The right of self-defense is individual or collective, which means that even if you are a small state and you don't have much of an army yourself, you can ally with some bigger, more powerful states. And if you're attacked, they can also defend you as well. And that's perfectly within the bounds of international law. So, for example, if the Russian Federation turns around and attacks Estonia, which is a small state with a population of about 1 million, Estonia has an ally, the United States, that has a very big army, and the United States is allowed to protect Estonia, and that is part of the self-defense exception to the general prohibition upon the use of force in international law. However, this self-defense exception is essentially temporary. It's essentially temporary because Article 51 says that states are allowed to defend themselves individually or collectively until the United Nations Security Council takes action. So if at a certain point, the United Nations Security Council says, we're sending in a peacekeeping force, we're taking action, we're going to kind of calm the situation down and so on. At that point, as soon as the action eventuates from the United Nations Security Council, the right of self-defense of a particular state lapses. So for example, let's go back to our fictional example of Estonia. Let's say the Russian Federation attacks Estonia. The United States sends a huge task force to help defend Estonia. And let's say Estonia and the United States are very successful in pushing back against the Russians. And in fact, they go so far as to push back against the Russians to the extent that they themselves invade Russian territory. And they are heading for St. Petersburg, they are heading for Moscow, et cetera, et cetera. Well, the moment that the United Nations Security Council says, okay, actually we have a solution here, we are going to impose a peacekeeping force, or we're going to impose some sort of solution on the basis of enforcement measures under Chapter 7 of the Charter. At that moment, the right of Estonia to defend itself, and indeed the right of the United States to assist Estonia in its defense, lapses. And rather, the plan that has been brought forward by the United Nations Security Council must commence. So individual or collective, but temporary. And obviously this had to be part of the apparatus, because states were never going to give up their right to defend themselves. And any realistic system for, let's say, the preservation of international peace has to include a self-defense norm. But it's maybe interesting to, yes, Iyad, you have a question. I'm sorry, I didn't know how long your hand has been up, but yeah.
Yeah, it's okay. Actually, I would like to open it for questions. We are now like 1 hour exactly. Yeah. So we can open it for questions for other comments. And I also have a question. Sure. As you have stated about the charter, I think it's very informative at what you're saying, actually. And it's about state and what happens when the state fails. Like you have Syria, state failure, you have Egypt that had a military coup, you had Iraq. What about this one question, the non-state Israel, Palestine as well, because Palestine is not a state. And what's happening there and what the charter has included in these areas, and also in Iraq and US invasion of Iraq, where they removed the Saddam regime and put another regime, and they did the same in Syria, but it failed because of Russia has refused to went and helped Assad to keep his regime. And then you have, as well, you said, Estonia, and how about the Russia-Ukrainian war, that Russia did not listen to the Security Council and invaded Ukraine in the purpose that they are protecting their interests. that Ukraine will not become part of NATO. So this is also some questions that I have raised up what the charter did for the non-state people who want a state, for example, and what about the resistance? So you were talking about self-defense individually and group defense. Did the charter also impact about resistance as well? So this is also one of, I have many questions, but I'll not take more of them. So maybe I see some people who raise their hands. What do you like? Do you like to take a collective questions, or you like to answer one by one? It's you can tell us maybe the procedure. Professor, you have any questions as well? If you have any as well, you can change. Yeah, maybe we'll start with Professor Lai as well. Yeah.
Yeah, thank you very much. This was very well structured and very interesting and good introduction in all these questions of international law of war and peace. Yeah, I would like to discuss many things with you. So maybe most interesting for my work actually is the question of sanctions. So I read a book which was published recently about sanctions in the League of Nations, and there was already the idea that sanctions are a weapon more lethal than war, and because they had made this experience that many people, hundreds of thousands, were starving already in the First World War because of sanctions in the Ottoman Empire, for example, and in Eastern Europe. But nevertheless, those sanctions were always considered as something you can choose and which is possible to choose. But they are somehow also against discrimination between combatants and non-combatants, government and population, because often the poor people in the country are suffering and dying and have no medicaments and things from those sanctions. I would like to know a bit more about the discussion on international law, because I think sanctions are not so an easy case that like it's taken now again in the Ukraine-Russia issue.
Okay, so we can take, you want to take others, or you want to answer this, and then we should take also a break, by the way. So if you want, we also need a break actually for all the listeners as well. What do you think? We can open what? Yeah.
So I think I'll answer yourself and Martin's questions first, and then we will take the other questions, and then I think we can have a break.
Okay.
I think there's already quite a bit to talk about with respect to the issues that you've raised. So I'll start, Iyad, with your question about non-state actors. I mean, basically, the idea of this session essentially was to give the participants a bit of a basic grounding in what international law is, where it came from, and what it's used for with respect to the preservation of international peace and the prohibition of war. And the title of the talk was, let's say the 21st century. And I wanted to talk about how effectively we're dealing with the system that grew out of the 17th and 19th centuries, has sort of been refined in the 20th century, and how to a certain extent it's less and less well fit for the 20th century, for the 21st century. And I think you've revealed some of the real fault lines here. The question of non-state actors is a really good one to talk about, because essentially even the concept of a state, whether it's a sort of a fit construct for the 21st century is perhaps questionable. Many of the states that evolved in Europe were to a greater or lesser extent nation states. So effectively you had a particular ethnic group or a particular political community maybe that formed itself within a particular geographical area and built itself up that way over a long period of time. And of course there was contestation over borders and so on, but there was a sense of shared belonging. Now, when decolonization happened, and this is particularly obvious if you look at a map of Africa, where there are a lot of straight line borders that have nothing to do with geographical features. When decolonization happened in many parts of the world, not just in Africa, in many parts of the world, essentially the conditions were not created for political communities in the same way to form. So effectively, the powers in the West had two options. They had an option to further the cause of international order or to further the cause of international justice. Furthering the cause of international justice would have been a lot more difficult because, of course, it would have involved drawing up all sorts of commissions to decide who gets what piece of land in, for example, Africa, Southeast Asia, South America, other places that were being decolonized. And it would have been a complicated, messy process. But rather, the United States and the Soviet Union in particular wanted fast, rapid decolonization. And as a result, the straight line borders that had been drawn by colonizing powers became the state borders in Africa and also in other parts of the world. And what this has led to, of course, is an increased level of contestation within particular states, that there's more capacity for states not to necessarily be representative of a particular people living within their borders. And international law deals with this pretty badly, to be perfectly frank. It doesn't give the same level of rights or representation to non-state actors. The only thing that it does, and this is actually a very old creation of international law, is that once a war starts, so let's say it's a civil war within a particular state's borders, a group representing non-state actors and a group representing the state within that war have exactly the same rights and obligations. So once a war starts, the laws of war apply equally to state actors and to non-state actors. And that means, for example, that there must be a distinction respected between combatants and non-combatants, something that Martin mentioned just now. That basically people who are combatants must wear military uniforms, carry their arms openly, and follow a chain of command. That both sides must respect the prohibition on attacking civilian targets, so that they can only attack military targets, etc., etc. But generally speaking, within international law, in terms of the representative organs, so for example, the United Nations, certainly within the Security Council, non-state actors have no power at all. Even within the General Assembly, non-state actors have very little power. So on some of the United Nations special organs, and indeed within the General Assembly, some non-state actors have observer status, which means that they can make observations and they can participate in debates, but they cannot vote. So their representation in the organs of international law is very limited. And for this reason, they are to some extent not dealt with very well by international law. And we can certainly go on and we can certainly talk about what you talked about previously, which is, state failure and places like Somalia and so on as well. There are many examples around the world of situations in which places are recognized as states, but in reality, they are not states. So if you look in northern Somalia at Somaliland, which is nearly half the territory of Somalia, for example, it's organized just like any state. They have a system where they have representative organs, they have a parliament, they have a government, they have a proper functioning tax system, and they have no representation on the international stage. Rather, they are represented by Somalia, which controls most of the rest of the territory, but which does not represent them. Moving to your question, Martin, about sanctions. I think the question of sanctions is an interesting one, because I agree with you. It's something that has the capacity to let lots of people starve to death and live in very harsh circumstances. And it is still a very imperfect tool. But I think in the domain of war and peace, all we have is imperfect tools, effectively. I think in trying to constrain states not to go to war or to cease warfare, it is seen by states as being the lesser of two evils. And that's probably why it's permissible. I agree that in certain circumstances it can be just as bad, but I don't think that's the case in all circumstances. So for example, at the moment, I think the sanctions in Russia are not intended to make anybody starve to death. rather there to make life politically uncomfortable for Mr. Putin. And yeah, it's to a certain extent up to Putin how he actually organizes the Russian economy. If it results in people, you know, really suffering at a certain level, the hope is that people will rise up against these regimes that are engaged in warfare and so on. I agree the question as to whether, you know, as to what we can do with respect to ensuring that sanctions respect the distinction between combatants and non-combatants is a tricky one. I mean, ultimately, I think this is part of the reason why one of the first sanctions that many states gravitate towards is arms embargoes. They say, okay, you can no longer import military hardware, military materiel into these countries and so on, to make it more difficult to wage war in the first place. But of course, in many circumstances, states have large military stockpiles, they're reasonably well prepared, and as a result, that's not an effective modus operandi. But I think one of the great problems of international law is that we don't have an effective series of sanctions, and that particularly when either one of the great powers, so one of the permanent members of the United Nations Security Council, is involved in a conflict, or perhaps even if they have a particular interest in a conflict, they're supportive of one side in a conflict, they will usually not support a resolution allowing for enforcement action under Chapter 7 of the United Nations Charter. And as a result, the main tool that international law provides for resolving conflicts is not available. So what are we left with? We're left with imperfect tools, a really imperfect toolkit. And you know, when you have an imperfect toolkit, for example, when you're trying to repair your car with an imperfect toolkit, you may not do as good a job or as fast a job as when you have the correct tools, but you can still do something. You can still try to do your best. And sometimes it will work and the car will go again, and sometimes it won't. But you try. So I agree. It's not a terribly heartening picture, but this is what we have at the moment.
Excellent.
Just a short reaction. I have some doubts whether sanctions are creating a weakening of the warfaring countries, or the countries creating problems. I think they are more getting them more power over the population and making the population more dependent of them. If it's not just weapon sanctions. With weapon sanctions, I completely agree. I think this is a good thing. And then the chances decrease that the population will dissociate from war. And I think people often think it's the other way around, but I see no evidence for this. I see it's more this problem that it's a bit also against the spirit which was strong after the Second World War, that the people hoped that the population will force the governments to end war. If you read people like Einstein, he said, I'm convinced that one day the population will force their governments not to go to war anymore, because they will not go to army anymore, and they will say, we don't want this anymore. We are very far from this, but sanctions are, I think, also not leading us closer to this.
Yeah, but I think sanctions in the Russian-Ukrainian war is really for the embargo, like the tanks. The Russians cannot create new tanks without the chips that are coming from US or European, the electrical chips. Yeah, this is what I wanted to say about it. So many of the tanks that are done by Russia cannot be done anymore. So they are using the old World War II tanks that they had in, which is much of them are not really working very well. That's why they could not, when they attacked Ukraine, the Americans' weapons were more advanced and they could defeat them because they were using the old way of military, because they didn't have the chips anymore. And this is the embargo that happened between the Europeans on the Russians that affect them harshly on the war. This is what I wanted to add.
For the newest generation.
Yeah, and the new tanks of Russian that it was limited for use, and this was one of the issues. So we have other questions, I guess. We can continue then the questions, and then we take a break. That's
Actually, I'll just ask my question as well.
Yeah.
So first of all, I apologize for arriving late. Technical difficulties prevented me. As one of my mentors would say, Christopher Mitchell, it was an excellent basic grounding. Excellent. And I think that all of us are going to be able to discuss some of what you presented today in future sessions. So I have a question, but also it's more related to your point of view, and maybe you want to take this towards the end, but I'll ask it now. What are your thoughts on the future of the state? What are your thoughts on that? It's a very big question, but yet it's something that, from your perspective, from international law, will be very valuable for us to at least hear your thoughts on the future of the state, especially given what we just went through with COVID, and there's a lot of changes taking place. So what are your thoughts on the future of the state and on the future of these imperfect tools? Did the recent events with COVID and the different changes in the world, did they affect the tools? And perhaps from your perspective, in terms of international law, will there be an evolution of them? Is there space for them to improve? And I guess for us, I think it's going to be very valuable to just listen to your comments and your views, and maybe you can leave this for later in the session, but I would really like to hear your perspective. Thank you very much.
Thank you. Yeah, sure. I'll leave it till the end. That suits the sort of
the ending.
ending. That's great.
Okay, Abdelghani, you can ask your questions. Abdelghani.
Okay, thank you, Professor, for the informative session. I don't like laws or politics, but it was very interesting for me because it gave me a lot of interesting information concerning this field. I'd like I have many questions, but the most relevant one to my topic, which is religion. So, can I ask you to give us an example of the connection between religion and law, particularly international law? Also, I'd like just to give one point regarding Professor Martin's point concerning the sanctions. There is I think there is a positive example, which is Ukraine and Russia, and there is another negative one, which is concerning Qatar and the Arabic countries around it, because it took 2 years and it was very affecting the people there. However, 2 countries helped this country, Qatar. Okay, so do you think that also this type of sanction concerning Qatar case, the Qatar case, is it there should be a kind of more steps, more serious steps concerning the countries which try to affect Qatar or not, the people. I'm talking about the Qatari people, okay? And also, I think that the Ukraine's example is not so, the Russia's example is not so more effective. It could be more effective if the whole countries around the world applies such kind of sanctions. But Russia, China, and some other Arab countries break such kind of sanction. So what do you think of that? Thank you so much.
Thank you. So maybe we can take another one as well, and then you can answer both of them as together. Yamir Ali, you can also ask questions. So you can kind of answer both at the same time.
Thank you, Professor. Thank you very much for your nice presentation. My question for you is international from the beginning is making us for the world to bring peace and justice, I think, as overall framework. But now, for me, it seems for a source of power for strong countries, militarily and economically. And could we continue, or just like Dr. mentioned before, the states will continue in such a way that the power of international law is the means for strong state to impose embargo as well as sanctions, then the rest of the whole population of the developing countries, especially Africa, like my country also, suffering malnutrition, food problem, insecurity, and also other things. So my question is that why the world especially those strong states, came or to try another solutions for bringing peace, like reconciliation and conflict transformation, rather than using huge amount of money and investments, drones, tanks, to kill innocent people and civilians as well. So is reconciliation, conflict transformation, and indigenous means of conflict or peace building mechanisms are highly costly, or that is not the intention of those strong countries to bring peace for the world, rather disturbing in the name of international law, in the name of using hegemonic power. So this is my view and my question. Thank you very much for having me.
Okay, well, thank you so much for these interesting questions. I mean, firstly, you know, the points about drawing links between religion and international law. I think the interesting thing to say is that international law is the history of international law. If you read an international law book and you look at the history of international law, there are many links to religion. I mean, we started to talk today about we started in the 17th century, but international law goes further back than that. And one of the earliest significant treaties that you have is the Treaty of Tordesillas between Spain and Portugal in 1494, so in the 15th century. And basically this was for the division of what was then called the New World, so effectively South and Central America between Spain and Portugal. And this treaty was basically it was negotiated by these states, but it was based upon arbitration conducted by the Pope. And effectively there is a sort of a cross-fertilization between religion and international law that goes back a long way. I mentioned 1648, the Peace of Westphalia. This ended the 30 Years' War, which was in part and in a large part a religious war. And one of the main outcomes of this was that states were expected to stop being entirely monotheistic entities, that they were expected to have a certain degree of tolerance for religious pluralism and so on, that if you were from a different religion and you lived in a particular state, you would not be persecuted. And many of the norms that we have in international law sort of flow from this. If you look at the modern history of concepts like human rights, which has become an important part of international law in the latter half of the 20th century, freedom of religion is one of the core provisions there. You know, freedom of conscience, et cetera, et cetera. So I think there are strong links between international law and religion on a number of levels. And I think it's something that we could talk about, you know, for hours and hours. But those are just a few sort of anecdotal examples. Unfortunately, I don't have time to go into more detail there, but certainly, yes, there are definitely strong links at different levels. The second question was about Qatar and the consequences for countries engaging in embargoes against Qatar. Well, the point really that I was making when we talked about the prohibition in international law on the use of force is that on the one hand, you have force, which is not allowed except for situations like self-defense or when the UN Security Council says it's okay. On the other hand, you have measures less than war, so effectively things like economic embargoes and so on. And while it's not very nice, there is no general prohibition upon doing this in international law. So if the consequences of these embargoes are, for example, mass starvation or severe human rights consequences, there may be a prohibition on that. But this didn't happen in the case of Qatar. So effectively, the Qatari people were not starving to death. There was no, you know, humanitarian disaster within Qatar, et cetera, et cetera. No, there really wasn't. I mean, I'm well aware of this. You know, Qatar is still a very rich country. And although its economy suffered slightly, there was, you know, the only reason anything bad happened in Qatar was because of choices that the Qatari government made. And Qatar throughout this period retained one of the highest GDPs per capita in the entire world. So, you know, it was not as a direct result of these sanctions that people were suffering in Qatar. It was rather as a result of the fact that the Qatari government treats migrant workers extremely poorly. So yeah, no, there will be no consequences for these countries, and international law does not foresee any consequences for these countries. I think the position of Qatar with respect to the its position between Saudi Arabia and Iran, having to share this massive gas field with Iran and then export a lot of gas through Saudi Arabia and so on. It makes its position geopolitically extremely complicated, but no, there would be no consequences for these countries. Yeah, the third question was about, well, basically the fact that the West is implementing sanctions against Russia, but effectively a certain number of states are allowing Russia to kind of circumvent these sanctions, namely China and India. Yeah, I mean, there's not very much we can do about that, effectively. Ultimately, in these circumstances, this is an illustration of why the system for the preservation of international peace that we have is not working effectively, because when a permanent member of the United Nations Security Council engages in aggressive warfare against a state that doesn't have many allies, such as Ukraine, it basically means that the self-defense provision in the United Nations Charter is not terribly effective, because Ukraine has a difficult time defending itself, and the collective action provisions of the United Nations Charter under Chapter 7 can never be activated, because Russia would veto such an initiative via a vote in the United Nations Security Council. So all we're left with is these sanctions and measures less than warfare. So yeah, non-forcible measures. But ultimately, each state can decide individually whether it participates in these measures. And if China or India decides not to participate in such sanctions, or indeed decides to help Russia, then they may do so. And there are no consequences for these states. That is their sovereign prerogative. They're entitled to make a choice. So there's the current system. And it's a very good illustration of why the current system is, to some extent, not as effective as it could be. The next question we had was about the nature of international law more broadly, and how basically, to some extent, international law can be seen as a means of, providing a vehicle for the exercise of power by strong countries to sort of marginalize smaller and weaker countries. I think this is definitely one of the kind of the core critiques of international law, that to some extent it preserves the status quo. I mean, even if you look at the countries that are in the United Nations Security Council, these are the sort of the 5 winners, if you like, or the 5 big winners of the Second World War. And to some extent, it's not the 5 most powerful countries now economically, et cetera. Why is Brazil not there? Why is India not there? Perhaps why is Germany not there? But equally, so international law is, although it is based largely upon this idea of sovereign equality, so every state is equal in terms of making the rules themselves, to some extent, do not reflect a situation in which all states are treated entirely fairly in every circumstance. However, there is good news for small and marginalized states. And that good news comes from a piece of bad news, and it is the climate crisis. Basically, something very interesting happened at the COP conference a few days ago in Egypt. And that was that the final communique that was to be issued at that conference was blocked by the G77 group, which is a group of, what one might call marginalized countries. And this was because they said, right, yes, we're also very interested in having climate justice in the future, but what about all the damage that rich Western states have done to our environment already? We want a fund established for compensation of the damage that has already been done. And none of the Western states were interested in this. None of them wanted it. Every single Western state was blocking this initially. But ultimately, they realized that they couldn't get action at global level without having these states on board. So in the end, this fund, and I think it's initially supposed to be $100 billion, was established. And the thing is that decolonization has resulted in a situation in which Although in 1945 and before then, the system of international law was established largely by what are now rich Western states, there are far more states in the world. There are about 200 states in the United Nations. Most of the states are non-rich, non-Western states. So if you need to do anything at a kind of a global multilateral level, you need buy-in from these other states. And there are some challenges that are facing the world at the moment that are going to require the buy-in of these states. And what that means is that I can see ways in the near future for states that are somehow on the periphery of international society to gain a much stronger voice in international affairs. And I think the climate crisis is probably the best example of that. It's not the only example, but I think it is probably the best example where it is absolutely essential for Western states to get a particular outcome where progress can be made on climate affairs. But the buy-in of the non-Western states is required. And as a result, I think from this perspective, a more, let's say, representative international law may well emerge going forward.
This is where my question was geared. So I think that's part of the question. I was hoping that you would speak about this because this is very interesting and is going to impact the next 10 years. As we know.
Yeah, absolutely. No,
Yes.
I mean, it's a super interesting development. And there have not been so many examples of this in the past, one or two, but this is really kind of something that was almost underreported in the media, where I think we are probably seeing the beginning of something significant.
I want also to reflect on that. Actually, in the conference in Egypt, also the human rights for international law was there, and they were requesting the Egyptian before the call for, climate change conference. What about the violation of human rights and international law that Egypt committed? And they want to be part of the international law at the same time and raise this, climate change conference. So this is also like you invade international law, and at the same time you portray that you are part of the international law, and it contradicts what's happening. And Western powers or the UN Security Council did not much about it, actually. And there was a lot of riots against it. And they are part of the G77 group as well, that they called for human rights for Egypt to respect international law and human rights. And even they had this British, journalist who was working for Al Jazeera, which is his Egyptian, British person who is in jail for now 5 years, and he didn't commit anything. He just he took a wrong footage and he thought it was the correct footage, and he put it on Al Jazeera, and it was the wrong footage. And now he's still in jail, and there's no any indictment for him. So this is part of what you were reflecting on what you said there. We have another actually question from Professor from Petra University who requested to ask about the legitimacy of self-defense when it comes for international law in cybersecurity. That is there any kind of anything mentions in international law on cybersecurity and self-defense? This is one. And what do you think if the Security Council would be accept to add more members that have more power, that not part of the superpowers in the Security Council? So these are two questions that were raised from Professor Omar from University of Petra. He's also professor of law. I think he is with us. I don't know if you want to comment on what he sent me, but you can answer as well.
Sure. So, I mean, international law and cybersecurity, yes, it's an interesting one because obviously the charter is from 1945 and it didn't, computers didn't exist back then. Broadly speaking, cyber attacks are quite an interesting sort of phenomenon from the perspective of international law. There is really only one example of a cyber attack that caused significant damage to infrastructure. That was the joint attack by the United States and Israel against the centrifuges in Iran's nuclear program, the so-called Stuxnet attack some years ago. And that's really the only example we have of a situation in which a cyber attack caused significant damage to infrastructure. In those circumstances, I don't think there's any doubt that that constituted a use of force, and that might even be classified as an armed attack. And that as such, Iran may well have had the right to defend itself against that armed attack by the United States and Israel. However, most of the other cyber attacks that have happened in recent years, so for example, the famous one is the Russian Federation against Estonia in 2007. Generally speaking, while they knocked out electricity, while they may have erased computer files, knocked out the banking system and so on, they didn't damage any physical property. And again, this is one of the problems that, how do you fit something like that into a system that requires a use of force or an armed attack, you know, you can't really quantify what happened there as a use of force or an armed attack. So the Estonians sponsored the creation of the so-called Tallinn Manual, which is a document that they created dealing with the customary law relating to cyber warfare and measures less than war and so on. So this is basically the state of the art with respect to cyber warfare. They have this document. If the professor wants to go and just Google Tallinn Manual, you'll find it online. We don't really have time to talk about the sort of the contours of cyber warfare, but it is a good example, I think, of why the system for the preservation of international peace that we have now is not really fit for purpose, because obviously, as we're seeing in Ukraine, albeit in a slightly different way, knocking out, you know, electricity, knocking out resources, you know, water provision, et cetera, to a particular country can be equally effective, can be a very, very effective means of pursuing a war, because it can completely debilitate a country. And you can do that with computers. It doesn't have to be with bombs. So it is something that we need to reflect on.
I can add actually on one thing that I got from Harvard, that I was studying cybersecurity, and the reason the pipeline in Russia is in effect is not working anymore is because the main reason that was stated in front of actually a lot of people who are influential in the US Army is because the Americans helped build that pipeline and they put a virus inside. And the issue was, if Russia attacks Ukraine, the virus will destroy the new pipelines that were built between Russia and Germany. And that's why, in my point of view, this is the truth. This was said to us by a military person, and they have said to Russia, if you invaded, we will do it. So Russia invaded, and as you know, the pipeline between Russia and Germany is now broken. And this is part of like cybersecurity, and Russia wants to build a new pipe that has nothing to do with the US. And this is like part of how cybersecurity can really make damage. And in this case, actually, this was in Harvard, by the way, in front of 64 US generals. And it was like, and what is the next stage? It was horrible that if Russia doesn't listen, one military agent from general said, we bombed them. We bombed Russia. That was their, I was sitting with generals who wants to bomb and not think of reconciliation or think of only peace or sanctions. They just want to bomb, attack Moscow, or fly nuclear planes over Moscow to tell the Russian Putin that we also have nuclear weapons and we can use them. But then you have then Trump left, lost his election, and Biden came in, so everything changed the way they were thinking. I guess this what's when I was studying in Harvard. What happened was Trump was in power. So they were like more into, not sanctions, just, attacking Russia. So I was at this how cybersecurity really attacks and makes, damages, real damages, not just, cyber attacks. And I think it should be part of the international law as well. And there's another guy who is a Tunisian, actually, and he was in Malaysia, and he attacks Israeli banks, and he stole a lot of money from Israel. And he would spread it all around, sending money to for Hamas, and he was caught by the Malaysian police, and he was sentenced to death. But then the Americans, took him, but then he disappeared. They don't know what the Americans did with him. He's with the Americans right now. He's a cyber hacker. And he's very well known. I think he's Algerian or Tunisian. I can't remember. I think Algerian, not Tunisian. And he was sending a lot of money for Hamas from Israeli banks. That was really unprecedented, and he was caught in Malaysia. So this is how cybersecurity can do, and also Abdelran is writing about the Chinese hackers as well, or Russian hackers as well. There are many all over, and this is part of WikiLeaks as well. So this is also goes in more and more debatable. So thank you. I think we should take a break now for like 10 minutes.
There was just one more question,
Yes.
which was from the professor, which was whether it would be worthwhile thinking about adding more members to the Security Council. I think I can answer this very quickly.
Yeah.
The answer I would give very emphatically is no, and the reason is that usually the problem is not that the Security Council acts in a way that is not representative of the whole world, or that, you know, that it doesn't, that it is somehow, you know, pursuing an agenda that is only good for the West. Rather, what usually happens is the Security Council doesn't act at all, because one of the great powers on the Security Council, usually either in practice Russia or the United States, is not happy with the proposed action and threatens to veto it, or does veto it. So the thing about adding additional states to the Security Council is more states, you know, more permanent members would mean more potential vetoes. So it's a deeply imperfect system, but expanding the Security Council, which has been proposed by a lot of people, would probably actually mean the Security Council does even less than it does now. And many of the conflicts that we have around the world now are due to the Security Council not acting. In fact, the most serious conflicts we have around the world now, so for example, in Yemen, are due to the Security Council not acting. If you look at the conflict that's going on in Central Africa, again, Security Council not acting. Were it to be the case that there were more states represented as permanent members, there would be more potential reasons for these states to veto action, and the system would become even less effective. So I don't think that's a reasonable proposal going forward. Okay, so I think, Iyad, if you want to propose a time for us to take a little break, and then we can reconvene and do the
Yeah, I
last
think
one.
10 minutes is okay. I don't know if all
Perfect.
agree with me. 10 minutes, you agree? 10 minutes, I think, is enough.
That's
Yeah.
enough.
Okay, so we'll reconvene in 10 minutes. So
Yeah, that's nice. 10 minutes then.
Yeah, and thank you, Ciarán,
Thank
very
you.
much.
Thank you.
Thank
I will
you.
leave now. Thank you. It's very inspiring.
Thank you so much.
thank you.
We drink
Thank
coffee.
you, Mr. Burke.
It's time. Let's go.
Okay, we ready to recommence?
Yeah, hello. Yes, yes. How you doing?
Okay. Good. So yeah, so let's continue. What I'd like to say for this second session is I've really been struck by the questions and the level of sophistication. Maybe I have pitched this thing a little bit too at too simple a level, because I can hear that a lot of you seem to know quite a bit. I know none of you are public international lawyers or really lawyers at all, so I was really just trying to give you a basic grounding. I will continue with what I was planning to go through. However, what I would say is that please, if at any point you feel we'd be better served by having a general discussion, or if you have a lot of questions, feel free to stop me. I'm quite happy for this to be a more discursive session. So with that said,
I think over that it was excellent. Yeah, it was an excellent session.
okay, well,
Yeah,
thank
so-
you, Iyad. I appreciate your your faith. I see we already have a question.
Yeah, you maybe can. Abdurrazak, maybe he's a new.
Yeah.
Definitely.
Yeah, thanks a lot, Dr. Burke. Thanks a lot, Dr. Iyad and Dr. Laura and everyone. Just regarding the international law and the absence of sanction, I think that when you mentioned that the absence of sanction is a big problem, but for me, it's not the absence of sanctions. It's the absence of just and fair sanction, fair international law, because you mentioned Qatar, you mentioned different states and so on. When you mention, for example, Qatar, it's like only Qatar that violates the human rights. Only Qatar that violates the human rights. So the problem is that the absence of, it's not the absence of sanctions or international law and so on, but it's the absence of fair international law or sanction that doesn't take, for example, or doesn't, deal with issues, based on double standards. There is double standards, ways of viewing the reality, tweaking the reality, or judging, the reality, or viewing the world. For example, I'm gonna tell you one thing. You talked about the World Cup, Qatar World Cup, and was objected by France and Germany and some many countries, European countries. But for me, and to my mind, for example, France, the last country that could talk about, let's say, violation of any human right. Because of what? Just the last month, let's give back the Algerian martyrs' skulls. So it's not the problem of the absence, but of finding, fair, just sanction or international law that's applicable to all the cases. And in this way, we can, let's say, impart a kind of stability. We can work for reconciliation. We can avoid conflict and so on. Thanks a lot.
Thank you.
Thank you.
I appreciate that. What I would say is that, let's say, with respect to the sentiment that you've expressed, I think I very much agree with the principle that we need a system that is applicable equally to all cases. And I think that's what a system of rules and a system of laws is supposed to do. And the point is, I suppose, that in 1945, the United Nations Charter was supposed to provide for a system of preservation of international peace that would apply equally to like cases, if you like. And later on, there was the elaboration of a system of human rights, which were supposed to be universal and therefore applicable in the same way to all people in all cases. Of course, we know that international law doesn't function like that in practice, and that's one of the problems, because obviously it's like anything. If you have, for example, take the United States. If you have a society in which Black people feel as though they are less well treated by police, then eventually they're going to get annoyed and they're going to start protesting, and it's going to, you know, damage the rule of law in the society, and potentially society can break down if there is systemic racism, etc., etc. Equally, in international law, if certain states feel as if they are being, and certain people feel they are being unfairly treated by the system, it's going to lessen faith in the system. And this is another point of contact, or let's say point of comparison between religion and law. Somebody asked a question about the sort of connections between religion and law. International law, because there is an absence of central authority, there is no sort of central government above us with enforcement powers. It only really works if we believe in it. And the problem is that if you have a lot of states that feel like they are being treated somehow unfairly or unjustly, then they will stop believing in it, and it poses an existential threat to the international legal system. You have to have a system in which all states believe that they are being treated more or less fairly by a system of rules that apply to all states, and that there is enough incentive for states to abide by these rules for the system to continue working. However, what I would say is that, on the other hand, international law is always sort of a balance between order and justice. One of my favorite examples that I always use in kind of international law classes about this is, if you think about how we learn about the Second World War and how we learn about Nazi Germany, for example, we tend to learn a lot about the Holocaust and about Hitler and the Jews and so on. But interestingly enough, the system that was put in place in 1945 really provided that, you know, for wars like the ones that Hitler started, if that happened post 1945, it would be possible to do something. But no mechanism was put into place in 1945 to stop something like the Holocaust happening again. So effectively, if, you know, a country had undertaken a sort of a genocide against its own people within its own borders, you know, so let's say there's no war, but there's just a Holocaust or a genocide within a state's own borders, the system in 1945 provided no remedies for that whatsoever. It said, okay, you have self-defense, but that presumes that, yeah, another country is attacked. So let's say no other country is attacked. You have enforcement action by the Security Council, but that has to for that to happen, there has to be a threat to international peace and security. So supposing a state commits genocide against its own people within its own borders, the Charter does nothing. Now, why did the Charter do nothing? Because that seems pretty fundamentally unfair and unjust and wrong in the context of what was going on in the 1940s. It did nothing because the architects of the Charter didn't think that they could solve all the world's problems at once, because they thought, okay, already it's very ambitious to try to put together a system that makes it very difficult legally for people to have wars. And we can't take care of wars and human rights at the same time. We have to engage in the prohibition of wars first in order to ensure order in international society, and we can deal with gross human rights obligations and gross human rights violations and so on a little bit later. And as a result, the system that we have even now for the preservation of international human rights is much less effective and much less, let's say, important in international law than the system that we have for dealing with the prohibition of warfare. So what I'd say is that despite the fact that it's important in international law that all states and all peoples are treated roughly in the same manner, international law is a really imperfect discipline, and it always has been, and it always maintains a certain fluctuation between preserving international order on the one hand and justice on the other. And I think, you know, it's still the case that it's more or less impossible to do both. But it's still, of course, better than the alternative, which is having no international law, which would mean we would have a lot more wars and so on. So it's an imperfect discipline is how I always describe it. Yeah, please, if you have a follow-up.
Thank you.
Please, another question regarding the international law. My question is that how we can, guarantee that international law is that pure entity that cannot be mixed with another thing. For example, in the current, the current period, in this, currently, we see the international law is mixed with some other things like energy diplomacy, like the case of, I mean, France, Germany, and Qatar, and then then we need to rely or to implement the international law for, I mean, obliging Qatar to, I mean, to give, I mean, gas and let's say like this. So the question is how to guarantee that the international, or how to protect the international law from it being mixed with another things like the any other thing like energy diplomacy and so on.
I think it's a good question, because of course we're in a world now where more and more factors are becoming relevant in terms of the preservation of international stability. And yeah, energy is an interesting one. I think again we already mentioned climate change. And I think the truth is that it will require some really original thinking by states, because I think at the moment the tools that we have are not necessarily ready for what we're experiencing. Let's boil it down to basic economics. If you look at the First and Second World Wars, which is where all this stuff we have in international law on the preservation of international peace comes from, the reason that states were willing to sign up to the current system is because the wars were so bad that even the states that won the wars, most of them suffered economically. So look at the Soviet Union. It was the biggest single winner of the Second World War, but at the end of the day, it lost 25 million of its best young men. And it's a demographic problem that Russia, Ukraine, and Belarus are still suffering from now. The kind of the echoes of this phenomenon. So, you know, even the big winners in these wars suffered terribly economically. And as a result, when it becomes a case that even if you win a war, you still don't gain anything economically, it's a lot easier for states to say, okay, we'll sign up to a treaty that prohibits warfare, because this can never be a good thing, and we want to limit the amount of wars that can go on. But on the other hand, if you look at, for example, the Amu Darya and Sir Darya rivers in the center of in Central Asia, basically these rivers are producing less and less water every year, and at a certain point, it's going to get to the stage that there will not be enough water for Uzbekistan, Turkmenistan, Tajikistan, and Kyrgyzstan at the same time, and there will be too many people living there with not enough water, and a solution will have to be found. And it will clearly, in the next 10 or 15 years, occur to the military, probably in Uzbekistan, because it is the strongest military power in this region, that it should invade its neighbors and take control of the waters, the parts of the river that are within their territory, in order to ensure water security for Uzbekistan. And as a result, the kind of the economic calculus that was previously the basis of the United Nations Charter system will be upset. It will actually be economically smart for Uzbekistan to go to war, because otherwise people in Uzbekistan will not have enough water to drink. And Uzbekistan is the second largest producer of cotton in the world. So, you know, Uzbekistan will not be able to produce cotton without lots of water. So we are facing unprecedented challenges, and I'm not necessarily sure that the current rules of international law are completely up to dealing with this stuff, because, as I say, the presumptions and the sort of the economic calculus upon which the system was based is now coming into question, with issues relating to energy, relating to natural resources, relating to climate change, and so on, presenting challenges that had not been anticipated by the drafters of the Charter in 1945. And this is in addition to other things like what we mentioned before, for example, humanitarian intervention, which was the big threat to international order, let's say 20 years ago, when NATO went into Kosovo, when Russia went into South Ossetia and Abkhazia, and so on. I see we have another question from Mudassir. I think you are muted.
1 minute. My question is that international law is equal to small state and big state, like Palestine, like Egypt, like Iraq, like Russia and Ukraine.
I'm sorry, can you say your question again? I'm not sure I understand.
My question is that international law is equal to small state and big state, like Russia, Ukraine, like Iraq, like Egypt, like Palestine. My question is that.
Okay, so the question of the equality of states. I think it's a very interesting question. So essentially, yes and no is the answer. International law is based upon this doctrine of sovereign equality of states, whereby every state has an equal voice. And if a state does not like a particular rule, it doesn't have to agree to be bound by that rule. So basically, international law is only the rules that states make themselves. But there are exceptions to this. So for example, if a new state comes into being, it more or less has to accept the rules that were made by other states before it came into being. Equally, if a state joins the United Nations, as for example, Switzerland did in 2002, it must agree to all of the rules of the United Nations, and it cannot change the rules of the United Nations unless all of the other members of the United Nations agree to change the rules. And of course, the rules of the United Nations organization are that certain states have more rights than others. So most, perhaps problematically, the 5 permanent members of the Security Council can decide upon enforcement action under Article 44 of the United Nations Charter, or they can veto enforcement action, even if it is backed by the other members of the United Nations Security Council. Now, I should say that in other international organizations as well, some states are stronger than others. But for example, in the European Union, if you look at the voting mechanisms within the European Union's organs, small states within the European Union are actually overrepresented. So if you look at the European Parliament, for example, Germany has a population of 83 million people. It gets 99 representatives in the European Parliament. Malta has a population of 400,000 people, and it has 6 representatives in the European Parliament. Now, of course, it means that in those circumstances, Malta has fewer, so Malta is less well represented than Germany, but it is a much smaller state, and per capita, sort of pro rata, if you like, it is much better represented. So actually, in certain ways, in certain organs, in certain systems, the small states are significantly better represented in international organizations. Equally, if small states work together and form coalitions, that can act as a power multiplier. And this example we gave from the COP27 conference is another good example, where you have the G77 group of nations, none of these 77 countries being particularly strong or powerful, but acting together and effectively acting as a block upon the agenda that Western countries wanted to impose, and ensuring that something that they really wanted, namely a fund for compensation for damage by Western countries to the environment of non-Western countries, would be established and funded with $100 billion. So let's say international law's perspective on the relationship between let's say strong countries and less strong countries is one based upon equality at a formal level, but then an acknowledgement of difference in different contexts and in different organs. But let's say that every organ in which acknowledgement of difference actually takes place, states also have to agree to the creation of these organs. They have to agree to the creation of these systems, and nobody forces them to participate in these systems. So yeah, it's all based from a starting point upon equality, but as we can appreciate, equality doesn't always work perfectly in practice.
Okay, we would like you to continue now, because we can take questions later more on at the end of our session, the last 10 minutes, if you have more time. I don't know how is your timing, so I prefer that you continue. And
I mean, to be honest with you, Ian, I'm also perfectly happy to take the next half an hour and discuss anything anybody wants to discuss. That's also fine. I mean, if the participants would rather ask questions, I'm perfectly happy with that. I mean, I think people have raised some quite interesting points and so on. And if it helps people to understand better, that's okay.
Okay, so we will give you another like 30 minutes if you want to continue your lecture, and then we open discussion for 10 minutes, and then that
Cool.
will be a very good idea to perspective to continue. What do you think? It's okay?
That's fine. That's fine. Yeah.
Okay, thank you.
So yeah, I think where we left it was we were discussing self-defense. And in cases of self-defense, force is employed on behalf of and in defense of another state. The International Court of Justice indicated 3 conditions for lawful exercise of collective self-defense in its military activities in and against Nicaragua case in 1986. First, the state concerned must have been a victim of an armed attack. Secondly, there must be a request from the state that has been threatened or attacked. In other words, international law does not permit the third parties, that is other states, to come to the aid on the basis of their own assessment of the situation. Rather, the state that has been attacked must ask for their help. And thirdly, there must be a request addressed by the attacked state to the third state. It follows from the judgment that the assisting state need not be under an armed attack itself. So as we mentioned before, the United States could assist Estonia if Estonia were attacked. However, it's also clear that the defense of one's allies can only occur at their behest. This raises questions about, for example, sudden devastating nuclear attacks when the government of where a government of a particular state is completely destroyed and where they can't actually ask for help. However, this was not contemplated by the court in the Nicaragua case. Anticipatory self-defense and preemptive self-defense entail the use of force preemptively to avert an imminent armed attack. Unlike simple self-defense, the normative grounding of which has been basically uncontested in international law, anticipatory self-defense has given rise to a lot of controversies. This is true despite the fact mentioned by the proponents of this justification that the right to self-defense, which now exists as a part of customary international law, historically did include certain anticipatory action. However, neither the wording of Article 51 of the United Nations Charter, which says if an armed attack occurs, nor purpose of interpretation thereof can support such an argument, given that the overall objective of the Charter is to restrict the capacity of states to employ force unilaterally. Anticipatory self-defense has been frequently employed in the Middle East, for example, in the context of Israel's strike on the United Arab Republic in 1967. It has also been resorted to in a number of conflicts as a cloak for drastic actions on alleged guerrilla strongholds and hubs of terrorism. Falling within the ambit of Article 2, Paragraph 4 of the United Nations Charter, any anticipatory force entails a presumption of illegality. A state threatened with the use of force may have a right to repel such a threat preemptively where the danger is imminent, the measures taken are proportionate to the pending danger, and the threatened state has exhausted all alternative means of protection. However, if a right to such action exists at all, it is a right which can be forfeited. A state which itself does not have clean hands cannot take such actions. In addition, the contours of such a right are very narrow indeed. The next possible legitimizing factor is recovery. In a loose sense, recovery is a form of self-defense too. The victim state recovers territory that is already under foreign illegal domination. When territory has been occupied illegally, the use of force to retake it may be argued to represent a lawful exercise of the right of self-defense. This was the justification offered by Argentina in the case of the Falklands Islands, or Islas Malvinas, in 1982, or India with respect to Goa in 1961. The trouble with this justification is, of course, that the alleged occupant of the territory rarely views its occupation as illegal, and that without any regulation by the international judicial process, the tug of war may easily grow into a full-scale war. As a result, part of the literature on recovery only permits the use of force where borders have been wrongly assessed and territorial control must be corrected, or when the state has a judgment issued by the International Court of Justice or another international tribunal, or the consent of the United Nations Security Council. In practice, this remains a point of contention. So we've talked about self-defense. Let's now maybe move on to enforcement action under Article 44 of the UN Charter by the United Nations Security Council. As we mentioned, self-defense and enforcement action are the two exceptions to the rule in Article 2, Paragraph 4 of the Charter. However, the question as to whether an act implies an illegal use of force or aggression is often a question of fact, the answer to which may be influenced by political as opposed to legal arguments. In practice, there are a number of factors which, at least in the opinion of the acting state, may legitimize forceful behavior otherwise deemed illegal under international law. The most important factors legitimizing the use of force or aggression are, for example, countermeasures or reprisals, or hot pursuit, but we don't necessarily really have time to go into them. Rather, let's perhaps move on. Having discussed the history of the prohibitions of the illegal use of force, we should now maybe look at the sort of the corollary of this, which is the obligation not to engage in acts of force and to settle disputes peacefully. So Article 2, Paragraph 3 of the Charter is a provision that doesn't tend to be discussed very much at all in international law textbooks. You'll usually only get a couple of pages on this. But in order for a system of international law to work effectively, and for states to actually refrain in their international relations from using force against one another, they need to have a realistic alternative, because disputes between states will arise. And to some extent, this is where Article 2, Paragraph 3 becomes interesting, and where your work on reconciliation studies becomes interesting. Basically, Article 2, Paragraph 3 prescribes an obligation for states to settle disputes peacefully. It also lists ways in which states may do this. So it talks about submitting disputes to the International Court of Justice or to other international courts. It talks about arbitration. It talks about mediation. It talks about so-called good offices and other alternative dispute resolution mechanisms. But what's interesting about the list in Article 2, Paragraph 3 is that it is effectively open-ended. And what this means is that the ways in which it is contemplated disputes can be settled peacefully in Article 2, Paragraph 3, that this list can be added to over time, and that this provision of the United Nations Charter can effectively evolve over time. And this is where sort of interdisciplinary studies of international law become quite important, where people like you become quite important. Because essentially, peace in the long term needs to mean more than the mere absence of war. It needs to mean something that is stable and provides a situation in which war will not just be averted for a few years and then maybe the situation destabilizes again and there's a fresh threat of war, but rather that war is, or the threat of conflict is averted in the long term. Now, how to do that in 1945, how to ensure that that happened in 1945 was through submitting disputes to the International Court of Justice or other international courts. It was through arbitration, through mediation, et cetera, et cetera. But as you're aware, the discipline of peace studies and reconciliation studies and other related disciplines has developed significantly since 1945. So now we have all these new tools. And where do these tools belong from the perspective of international law? Well, they belong in the list in Article 2, paragraph 3. They belong as the sort of the corollary, the mirror image of Article 2, paragraph 4, which says you may not go to war anymore. But accepting that international disputes arise, we need to use, and we talked about toolkits earlier, we need to use the most effective toolkit we can possibly have to stop the wars from breaking out in the first place. And as a result, it's extremely important that we develop the toolkit from Article 2, paragraph 3, in order that we're not resorting to force under Article 2, paragraph 4. So this is why what you're studying, what you're working on is so fundamentally important. And this is probably the closest link between your discipline, your work, and international law. Because essentially, we need to have an alternative to war. And as we know, the system that we have at the moment, the system of international law, is perhaps a poor fit for the 21st century. As was mentioned in the questions earlier on, although the system of international law that we have contemplates state conflicts between states, so one state using a war, using force against another state, many states now get involved in conflicts with non-state actors, or conflicts that are not typical interstate conflicts. These can include civil wars. They can include wars involving failed or failing states. And they can also involve situations in which there are gross human rights abuses. So we mentioned previously that at the end of the Second World War, the system that was put together was designed to stop further big wars from breaking out, but it wasn't really designed to do anything about human rights and to do anything about the prevention of genocide, et cetera, et cetera. But in the meantime, between 1945 and now, we've had massive progress on human rights. Many important human rights treaties, the Genocide Convention in 1951, the Refugee Convention, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the Convention on the Elimination of Discrimination in All Forms Against Women, et cetera, the Convention on the Rights of the Child, many, many, many other international conventions concerning human rights. And these have come to occupy an extremely important position in international law. But ultimately, the question then begins to be asked, well, what if a state is engaging in gross and systemic human rights abuses against its own citizens? You know, can its neighbor intervene to stop this? The answer in 1945 would have been no. The answer now, well, it's a little fuzzier. Some human rights scholars would say yes. Some sort of black letter international law scholars would say no. So we're dealing with a situation in which the cracks in the international legal system are beginning to appear, or have been beginning to appear for the last 20, 25 years. These cracks caused by the clash between traditional international law banning the use of force on the one hand, and more modern international law protecting human rights on the other. Cracks caused by things like cyber warfare, which were also mentioned. You know, it doesn't fit our typical definition of the use of force. Where do we put this? Cracks caused by the fact that many of the wars we see now are civil wars, but they are civil wars that in some circumstances may spill over borders, may have cross-border effects. You know, what about wars that cause massive refugee flows, for example, like the war in Syria? Can this be determined to be something that causes a threat to international peace and security? What about the notion of climate change and what it's doing to the world? You know, where we can more or less be assured that there's definitely going to be a war between Uzbekistan and its neighbors in the next 15 years, and what can we do about it? Similar things can be said perhaps with respect to Egypt and Ethiopia, with respect to this dam that's being built in Ethiopia. So we're dealing with a situation in which rules that were drawn up in 1945 have served us pretty well until now. There have been wars, and in fact, there have been a lot of wars, but relative to the wars that came before, they were quite small scale. What's come now is a moment at which The regime is sort of under attack from all sorts of different directions. And it will take creative interdisciplinary solutions to find some fresh ideas to keep the discipline, to keep international law on the road. I think we had one very provocative question from Laura, which was, about the future of the notion of the state. I don't think we've ever quite got back to this. Basically, are we looking at a world in which not only the prohibition upon the use of force and the system of preservation of international peace needs to change, but indeed the notion of the state needs to change? Well, the truth is that the notion of the state, in my view, has already changed more than perhaps we're prepared to admit. And this is happening both in terms of, it's happening around the world in different ways. A lot of this is to do with the fact that multinational corporations now hold more capital and more resources than many states, and that they are powerful in a way that is that had never really been contemplated when states were being created. If you look at the writings of Thomas Jefferson, for example, basically he said very clearly that he didn't really believe in the notion of government without information, and that if he wanted there's some famous quote which I'm not remembering very well, but that if he were faced with a state with a government but no newspapers, or a state with newspapers but no government, he should not hesitate to prefer the latter. We are living in a world where invariably people are either faced with too little information, such as in China, or with too much, such as in the West. And in either state of affairs, the population are relatively easily manipulated in terms of the choices that they make. And those who manipulate them, at least in the West, are people with a lot of money, to put it simply. Multinational corporations in general, they have enough money to control politicians and to control the government. From this perspective, the interests of multinational corporations are increasingly served by states rather than the interests of people. This is why, you see multinational corporations getting tax breaks and people sleeping on the streets in rich countries like Germany, the United States, all around the world. Citizenry is no longer the primary protected group. Equally, the notion of the state has come under attack significantly from cosmopolitanism, basically. There's a German political theorist that I would assume you've all read, because he doesn't belong in international law, but you probably know the name Burke. And Burke's theory essentially is that you can't have a state without having a political community, and that this is something that is basically required as the sort of the central condition of statehood. As I mentioned, many of the states that created international law, Western states, were based upon a sort of a coherent political community with a lot in common. Individualism means that people have less and less in common as time goes on. And this is also going to pose a significant challenge to the state. I mean, what is the identity of a state based upon, if not on a common conception of a political community? Equally, outside of the West, in other parts of the world, not everybody is terribly happy with living forever in states that were created on the basis of artificial borders that are a hangover from colonialism. And contestation in that regard is becoming more and more prevalent. So where the notion of the state goes from here is an interesting question. The reason that international law was successful until now to some extent, and that it has been able to provide the order that it has been able to provide, was because the notion of the state was a fairly uncontested notion, and a fairly stable notion. And I'm not necessarily sure that it will remain so going forward. So perhaps that's another threat or factor that we can have regard to alongside climate change, the issues with respect to political contestation, human rights, etc., etc. Okay, I will leave it there, and I will open the floor for some questions.
Thank you very much. That was a really excellent reflection on your part. I think we're going to be speaking about this again, so thank you so much for that.
Thank you. Thank you. So I will start with a question actually, and then I'll give it to the PG students. So how do you reflect the work of international law on the Sustainable Development Goals and the 2.3.4 article and paragraphs on the Sustainable Development Goals, because they are replacing what the UN is funding and replacing the international law, and they say, okay, we want to give something to the world. They gave the SDGs, and they have them now about 7 SDGs, and how you can connect them with the international laws and the rights that they are working with the states and interstates and governments and NGOs. Can you reflect on that?
Yeah, I mean, let's say the Sustainable Development Goals, they don't come from nowhere. You know, I mean, the first thing is that by making these goals, it's a very we have something in law called hard law and soft law. And hard law basically means you have an obligation to do something. Soft law means that, you know, effectively it's a recommendation. There is no obligation. And the Sustainable Development Goals, although they're something adopted by the United Nations, they are definitely soft law. They themselves do not place any obligations upon anybody. And as far as I'm concerned, they are there because there is not enough state will to actually do any of these many of these things in an effective manner. If you look back to the famous 4 Freedoms speech by President Woodrow Wilson of the United States in 1918, I mean, you know, he talks about freedom from fear and freedom from want as being, you know, the 2 basically most fundamental things that every human should have. And if you look at the Sustainable Development Goals, if you look at goal number 1, no poverty, goal number 2, zero hunger, those are freedom from want. You know, if you talk about sort of, freedom from fear, well, fear of what? Fear of lots of things that are also set out in the Sustainable Development Goals. I think the issue is that many of the Sustainable Development Goals also reflect values that were set out in the International Covenant on Economic, Social, and Cultural Rights in 1966, which was basically the multilateral human rights convention that was sort of sponsored by the Soviet Union. But at the time, these values were very much seen as being inimical to Western values. They were seen as being sort of incompatible with Western individualism because, you know, the idea that you would have reduced inequality, well, how do you reduce inequality without state intervention, without charging higher taxes to rich people and, you know, lower taxes to poor people and giving people support and so on. So to be perfectly frank with you, I think the values that are set out in the Sustainable Development Goals have been there for a long time. And I think there is no obligation on states to do anything with respect to the Sustainable Development Goals. I'm quite sort of pessimistic about the Sustainable Development Goals, to be perfectly honest with you. I see them as more or less a cynical marketing exercise. I think if you want states to achieve anything, you have to get them to agree to do a specific thing by a specific time. You need to have obligations. Just having recommendations and so on, if you don't get them to sign up to clear targets, then these goals are not worth very much, I'm afraid.
Thank you. Thanks so much. So I open also questions for our doctoral and guests and professors. Abdelghani, you can ask your question, Abdelghani.
Okay, thank you so much. I'm asking about your opinion concerning such exceptions, intervention using self-defense, enforcement action, humanitarian, and so on. For example, the case of the United States when they entered Iraq, Afghanistan, and Syria. Okay, sometimes they say that it's a self-defense. Sometimes it's a humanitarian in Syria. Okay, in order to save the people from Bashar, for example. So, do you think that these exceptions are put or set in order to justify what such countries or such people in charge of these countries would like to do or not? Also, concerning the veto dilemma, what do you think of the veto dilemma concerning your own experience? Thank you so much.
Okay, so the first question first, are the exceptions self-defense and humanitarian intervention there to kind of justify what these great powers want to do? Absolutely not. No, self-defense is there because no system could ever be designed in international law where it would be permissible for one state to attack another, and there would be no legal right for the state that was attacked to defend itself. You have to have self-defense because, of course, every legal system around the world has self-defense. If I come up and I punch you in the face in the street, of course you can defend yourself against me, whether we are in Ireland, whether we are in Afghanistan, whether we are in Australia, whether we are in Gambia. It doesn't matter. You can defend yourself if you're attacked. And it's the same principle in international law. Every system knows self-defense. That would have to be provided for. With regard to humanitarian intervention, I also don't think it's just there to, serve as a justification for strong states and so on. I actually think that there is some logic there, because if you think about it, if a state is really engaging in, for example, gross and systemic human rights abuses against a portion of its population on, for example, ethnic grounds, if it's just executing genocide against a proportion of its population, then it's logical to say that we all have an interest in things like that not happening in the world, and maybe there should be a right to intervene. And it hasn't always been big, powerful states that have intervened. So if you look at the intervention of Vietnam and Cambodia in 1974, for example, against the Khmer Rouge, you can see a situation in which a very, very poor state in Vietnam decided to intervene in its neighbor to stop what was basically a slaughter going on next door. Now, that is not to say that these grounds, these exceptions are never used by great powers as justifications, and are never used in a cynical way. They are, don't get me wrong, they are used in bad faith, they are used very cynically, and their very existence is kind of dangerous. But unfortunately, I don't see how you can design a system without having something like these categories existing, because they can also be used for good. Ideally, you would have a situation in which there was an organ like the UN Security Council, but maybe it could be a different organ, that would have the power to more or less decide every time whether there could be something like humanitarian intervention. But of course, as we know, the system is imperfect. So bringing onto your second question about the veto, what do you do if there is a veto, and that there is a there are gross and systemic human rights abuses going on in some country, but for example, China doesn't want anybody to intervene because in this country is their ally. The veto is a real problem. I mean, there's probably no bigger problem in international affairs and in the way in which this system works nowadays. Because, you're talking about 5 of the most important states, most powerful states in the world. And even if they're not directly involved in conflicts, they often have an interest, they often have an ally, they often have somebody that they want to be victorious in this context. And that means that they are, it doesn't even mean that they actually have to block anything, because often there is no vote, because basically it's already diplomatically communicated that, oh, well, if you have a vote, we're just going to veto it anyway. So it doesn't even come to a vote. But the fact that the veto is there is a real problem. And of course, it would be nice to think about a way of doing it more democratically, more representatively. But unfortunately, it's a lot more difficult to reform a system once the system already exists than at the moment when the system is being invented, if you like, And I think it will probably take another really serious crisis before the world is ready to replace the system that we have.
Thank you so much, Professor. We have Abduraza. Abduraza, you can ask your question.
Yeah, thanks. Dr. Burke, you mentioned the idea of self-defense, and self-defense suggests that there is a continuous or ongoing, ongoing dispute, ongoing conflict, ongoing war, if we could say it this way. So I'm just trying to envisage or to portray or to depict a kind, like to portray a picture in which we have self-defense, in which suggests, as I said before, continuous ongoing war and reconciliation. I mean, when I'm talking about reconciliation, I'm talking about Hölderlin perspective, which is reconciliation in the mid of conflict. This is one thing. Another thing is how to portray. I mean, for example, like a picture, if we want to draw a picture in which we have self-defense and Hölderlin perspective, and the constituent or the component of reconciliation, apology, forgiveness, and so on. So if there is attack and counter attack, so what is the need for apologizing? So, and what's the need for forgiving? You know, that's for me, just like I'm trying just to have all this concepts together to understand the process of reconciliation when it comes to the international law. Thanks a lot.
Okay,
you got my point. You got my question.
I think I did, yeah. Or I will try to answer it anyway, and you can tell me if I didn't understand. But no, I mean, obviously, look, the Hölderlin perspective, you know, this is something that I've read about, but it's not really part of international law. It's really belonging in the domain of reconciliation studies. But what I can say here is that I think the idea behind it is that even if you are the person who has, you know, your state has been attacked and all you really have done is kind of defend yourself. So you really see the other person as being completely in the wrong. That the idea of an exchange of mutual apologies and so on and mutual forgiveness might seem a bit artificial in those circumstances. And I kind of agree, but I actually come from a country where, you know, a lot of people had to do this. So I come from Ireland, and when I was a little boy, there was still war going on in Ireland. And basically both sides really thought that the other side, you know, well, particularly our side, we really thought that the other side had more or less been completely in the wrong during the conflict, you know, and that we had nothing, you know, to kind of, yeah, apologize for, or, you know, ask for forgiveness for, whatever. But here's what happened. The leaders, they apologized, they asked for forgiveness, they put together a solution which was really based upon everybody trying to take as much responsibility as the other side felt was necessary for reconciliation. And what happened next was that, you know, kids got to go to university, kids got to live in peace for the next 30 years, you know, people got to rebuild the society, et cetera, et cetera. So I think even in those circumstances where, and I'm speaking here as an amateur, this is not really my domain, but even in circumstances in which it might feel very difficult to give this apology or difficult to say these things, it's kind of worth it for the result. Because if you look back after 30 years, even if you had to say something you didn't really want to say, that if this gets the person on the other side to kind of forgive you and to make that step as well, then it doesn't really matter if you meant it at the beginning, if you really felt like that it was deserved, if you like, you know, if you kind of can still meet in the middle and go a little bit further than you thought you had to, then yeah, you know, I was lucky enough to grow up in a peaceful society because of this, you know, and I think that's my perspective anyway. But look, we're getting a long way from international law here, I'm afraid.
So if we think in this way regarding, I mean, in relation to the international law, don't you think it's a high time to reconsider, I mean, this concept of self-defense, so as we can foster or promote reconciliation? Because if we believe self-defense, it means there is an attack and counter-attack. So it's continuous. I'm attacking you and you're attacking back. So there should be something that should be done in terms of, I mean,
basically, don't forget that self-defense only applies until the United Nations Security Council acts. So once the Security Council acts, self-defense right is basically extinguished. But as I said, I don't think you're ever going to get states to sign up to a system, and international law is only ever going to be what states agree that it is. I don't think you're ever going to get a situation where states sign up to a system where there's no self-defense allowed, because they're saying, okay, if I get attacked, I can't defend myself. That's ridiculous. But the point is that the Security Council, I mean, basically what we should be putting pressure on, I think, is for the Security Council to react quicker in circumstances in which there is an attack and then there's self-defense. Because the Security Council can also take measures less than more. They don't have to authorize the use of force. They can do other things as well. And it may be that they're able to intervene and they're able to do more than they do. But look, again, this isn't something that is typically talked about as being one of the modern threats to the international rule-based order. But you're absolutely right. You know, self-defense is a big problematic category, and there's no kind of magic spell that is going to kind of fix this overnight. It's tricky.
So I think more that what he was trying to say, let's say, how can international law intervene to develop reconciliation in the middle of conflict? I know it's a big, huge topic, but I want to understand if you have any perspective in how reconciliation, conflict transformation, and peace can be intervened within international law if you have tackled with this kind of issues. Like, now we know that international law, you know, how it works and how the charter works with international law, but can it intervene to develop reconciliation process in the middle of conflict between two states? So did they do something like that, or the reconciliation is not part of what the UN's perspective or Security Council or to develop? But we have reconciliation in South Africa, for example. They supported that, and other places like Colombia or like Korea, or Rwanda, for example. So what is it? Does the international law can support reconciliation process? This is my reflection on, and what do you think about it?
Well, I mean, at the end of the day, let's say international law is just a system of rules. That's all it really is. So let's say there is an obligation upon states to settle their disputes peacefully. And this obligation is all of the time. Even when they've already started a war, they are legally obliged to try to settle the dispute peacefully. And as I said, in Article 2, Paragraph 3, it sets out a number of ways they can do that, such as taking the dispute to the International Court of Justice. But that list of ways they can do it is open-ended. And in my view, it has evolved since 1945. So that in 1945, there were only a few ways you could settle disputes peacefully. Now there are more. And that's where reconciliation studies belongs, if you like, where reconciliation can take place even during a conflict to bring people together, to try to get them to talk, to reconcile, to, you know, negotiate, et cetera, in a variety of ways. So the obligation really is for states to do everything that they can to settle their disputes peacefully. And if that means that, you know, a model of reconciliation is the best way to do that, then they are legally obliged to take that step, which is a pretty significant way in which international law contemplates the inclusion of that. Now, whether international institutions do that all the time is another question. Of course, they do not. They you know, the United Nations is not always as let's say activist or forward thinking in this as it should be, but broadly speaking, yes, there is an obligation there.
No, okay. I think it's very important to connect reconciliation with international law. I think it's a part of it, to embed it and not to implement it, but to give it as a chance to people understand this concept, the nations that are in conflict. So this is where I thought it might intervene, but I think it's a good idea. And yeah, I agree with you as well on that concept. Yeah.
I was just going to add that from my point of view, it seems that like you said, international law has a set of imperfect tools, but it's also there to serve the world in a sense, right? So if we take it as part of that service, then it's probably the states and then people like us that are studying, that are either practitioners or scholars in reconciliation, the parties themselves that are actually going to be the ones that push those imperfect tools to evolve to the needs of these two parties. They want to reconcile as X and Y, and international law, in what article can we fit this and how can we, so I think it's going to be from that side of things that we're going to be able to see reconciliation become more prominent in international law. It's not the other way around. I think it's going to be from the parties and people that are studying and practitioners towards this set of imperfect tools, because they're just there for us to use, to serve, and to have a better quality of life for all, I think, at the end of the day.
Absolutely.
That's
very
what
well put.
that's how I
Yeah.
perceive things.
So do we have any other questions that we have some Abdulghani has raised a question? Yeah, Abdulghani, you can have a question if you like. Abdulghani, did you raise your hand?
Yes. It's not a question, it's a recommendation or a suggestion concerning the religion. As you said, the religion has origin or a root related to a deeply rooted relation to the international law. Okay, why can't we use it nowadays in interdisciplinary approaches, academic studies, to reform and to reinvent something? I'll give you an example, just one example. From the Islamic, for example, Islamic Sharia or Islamic legislation, Islamic law. Okay, the five main objectives of Islamic laws is to uphold or to keep one's and the others faith, life, intellect, progeny or breeding, and property. So it's a duty and it's a right and a duty. Okay, it's my right and my duty to keep the five. Okay, so why don't we use collective religions or mini religions in order to have such a kind of obligatory enforcement or to come into force? Okay, so we have some international figures like the Pope and Sheikh Al-Azhar or the Azhar Imam and so on. So why don't we have such international academic and political conferences and academic interdisciplinary approaches? That's my point of view. Thank you so much, and thank you so much for such informative session.
Thank you, Abdulghani. Thank you. Yeah, Professor Ciarán, do you like to answer him for Abdulghani? Do you have any comment for him?
Yeah, well, I think it's interesting, like these five principles, they're also quite similar to some of the things that we saw set out in the Sustainable Development Goals, to be honest with you, and some of the values. I think this is quite interesting, because I think, a lot of the values that we talk about and a lot of the values that are set out by many of the major religions, whether it be Islam or Christianity, are quite universal. I mean, we all care about the same things. We all want, a better world. And I think there's definitely room for that. There's definitely room for sort of dialogue and so on. What I would say is, we need to try to create institutional vehicles for that to happen. And it's tricky because, I mean, there are forces in the world that are quite hostile to religion, unfortunately. There is a kind of a growing atheist movement and so on. And it's not that people don't have the right not to believe as well as to believe, but I do think that, yeah, religious movements and so on can be definitely part of the solution and part of reform going forward. Yeah.
Yeah, I think as well that not everyone is monolithical religion. Some people are atheists, some are Buddhists, some people are Sikh. So we cannot just implement the three religions and bring the whole faith that the whole world has three religions. So this is not the disputable. Therefore, international law and academic people are more wanted than going after religion, because everyone has his own religion. Nevertheless, the own religions, those three religions, have different factors. Like Islam has 7 factors. Christians has another 7 churches. Judaism has different tribes, different ways of being a Jew. So even those inside are different than each other. And then when you go to atheists, and then you go Buddhism, who are different than each other, and then you go to Sikh. So we cannot just implement any religious kind of task. And I think that's why international law is more important than reflecting it on faith, actually. So that's my take on that. So I think we are now reached our 5:10, so 10 minutes. I think we are We thank Professor Ciarán for his intellectual enlightenment of international law. I think it's very important, and it is also reflecting on our studies on reconciliation and peace studies as well. We have discussed the paragraph 2.3 and 2.4 with him, and which is really very, very intrigued and interesting. And we discussed also the UN Charter for Peace as well, and we discussed the self-defense and the attack, with some many aspects that can be here really used in our research. So yeah, thank you very much, Professor Ciarán. The one thing I would like to add is don't forget, we need from you an article, and now we are in a phase, we need the title. If you can send me the title, it would be an excellent idea.
Sure, of course, I will do.
Yeah.
Thanks so much, Ciarán, for organizing this. Thank you all for attending. I mean, if anybody has any questions further or whatever, you can always email me. Iyad will send you on my email address. I'm very happy to have participated. So thanks once again, and have a great Friday evening.
Thank you so much.
Thank you very much.
Thank you. So everyone, have a good night, and thank you so much for passing. I just have one comment about the Armenia. You have to send me your CV so I can also put it online for all the PhD students who are on this, as part of the Armenia PhD program. And thank you, Karen. We will have you always with us, and we might have a PhD student for you as well. Thank you. Thank you. Yeah. Thank you. Have a good one. Ciao.
Good night.
Ciao.